Good afternoon. Our topic for today is about penalty. In this particular chapter or title, you will be studying about characteristics, classification of penalties, its duration and effects, as well as its application and execution. To start with, we will have penalties in general. So what is a penalty? Penalty is actually a suffering that is inflicted by the state for the transgression of a law. By the term suffering itself, it signifies pain. So there are actually judicial conditions of penalty, that it must be productive of suffering without however affecting the integrity of the human being. In other words, that the penalty imposed upon you must not degrade your being a human person, and your stay therein, suffering from the penalty imposed upon you by the court, must be productive because it is somewhat useful when you are actually released from prison. Must be commensurate with the offense. In other words, that according to the gravity of the felony committed by the person, the penalty to be imposed upon him would be commensurate to the felony he commits. So if he commits an afflictive felony, then the penalty to be imposed upon him would also be afflictive, which is higher as compared to if he commits a light felony, then the penalty shall also be commensurate to the light felony. Must be personal. Personal in the sense that no person should be punished for the crime of another. The person who actually commits the crime should be the one to suffer for the consequences of his act. Must be legal because it is only possible after judgment rendered by the court. You cannot be made to suffer penalty unless the same is rendered by a court after trial. Must be certain because no one escapes its effects. Later on, you will learn that for every penalty imposed by the court, it also carries with it some accessory penalty, and that is expressly provided for by law. Equal to all and must be correccional because it applies, the penalty as provided for by law applies to everyone irrespective of your status in life. And you have there that it must be correctional because what I have mentioned earlier under the first part is that this same is productive of suffering, meaning to say the purpose there is for your reformation so that you can use the same upon your release from prison. Purpose of the state in punishing crime is to secure justice. Okay, so that is the primary purpose there of the state. Take note of the theories justifying penalties, but these are actually theories. It may be true or not. Prevention. Is penalty really for prevention? The purpose there is to prevent or suppress danger. Somewhat, we can say that yes, that theory has basis because it actually able to suppress the danger to the state. Or some may say that theory is not after all true, or the maybe the most accurate term to use is it's not that effective because even before we impose, we still have the death penalty. It did not actually prevent the commission of those crime punished with death penalty. So that could be. It's just a theory. Self-defense. It is self-defense in the sense that the same is to punish the criminal as a measure of self-defense to protect the society from the threat and wrong inflicted by the criminal. Somewhat, some would say yes, that theory has basis. Some would say not so. Okay, just like the prevention. How about for reformation? Take note that inside the penal institution, they were being thought of life skills. They were thought of some alternative to learning. They were thought to pray. They were thought some livelihood that in the hope that when they are finally released from the penal institution, they can use those things that they've learned inside to be a better person. But somewhat, some would say, wa man lagi na nausab, even if he stayed so long inside the penal institution, but the same, he still continued to commit crimes. Okay? And you have their exemplarity to serve as an example to deter others. So somewhat true because some actually were deterred from committing the same felony committed by another one. So it sets as an example, and then justice as an act of retribution for the act committed by the accused for transgressing the order or peace of the society. Now take note that these are theories that seeks to justify the imposition of penalty. These are the noble purpose that the penalty is imposed, but somewhat we can say, or in our opinion, or some of us would opine that the same is not that effective, while others would say, oh, that theories actually is true and it really justifies the imposition of penalty. So let's just say that it would be on a case-to-case basis because after all, human has free will. Okay? So you have there the threefold purpose of penalty. Retribution or expiation, the penalty is commensurate with the gravity of the offense. As I've mentioned earlier, so if the person commits, let's say, homicide, the penalty to be imposed upon him is reclusion temporal with a duration of 12 years and 1 to 20. So the same is commensurate to the crime he commits. But if he commits, let's say, slight physical injury, which is only a light felony, so the penalty commensurate to that is given by law is only arresto minor, that is 1 day to 30 days. So meaning to say, commensurate depending on the gravity of the offense charged and committed by the accused. Correction or reformation, as shown by the rules which regulate the execution of the penalties, consisting of the deprivation of liberty. I've mentioned earlier that inside the penal institution, you consider in that the purpose of the law which imposing the penalty is to seek reformation or correction upon the convict by the rules and regulations that they have there inside with that purpose of seeking reformation or reforming that particular convict to be a better person when he will be released from prison. Social justice shown by its inflexible severity to recidivists and habitual delinquents. What does this mean? That while our purpose there is to reform and the penalty is commensurate to the gravity of the offense, but if the accused is a recidivist or a habitual delinquent, the accused who is a recidivist there, the same is an aggravating circumstance wherein the penalty to be imposed upon him will be in the maximum period. While if the accused is a habitual delinquent, an additional penalty shall be imposed upon him on top of the penalty to be imposed of the crime he commit. Who is a recidivist again? So he is a person who commits the second felony embraced under the same title of the code, meaning to say the first felony and the second felony is punished under the same code, under the same title of the code, while the habitual delinquent is a person who commits the crime of serious and less serious physical injury, theft, swindling, and falsification the third time or oftener. So somewhat murag nagmaster na on those kinds of felonies. So this one is an aggravating, this one additional penalty. It's one of the aggravating circumstances, but the law imposes an additional penalty if he is a habitual delinquent. When shall a penalty be imposed? Article 21. No felony shall be punishable by any penalty not prescribed by law prior to its commission. What does this mean? That a person can only be made liable for a felony if, at the time of his commission, there is that law defining and punishing that act or omission. In other words, if on the day of his commission, there is no law that defines and punishing that crime, then he cannot be charged over that act or omission even if a subsequent law is passed punishing that act or omission. Okay, as a rule, law first, defining and punishing that act or omission. Then it will apply to all persons who commits that act or omission after the passage of the law. But if he commits it prior to the passage of the law, then he cannot be made liable. Meaning to say, if a penal law is passed, it cannot be given retroactive effect to his act committed prior to its passage. It cannot punish his act or omission done prior to its passage. Example, if a law is passed in 2004 punishing husbands deliberately depriving their wife of financial support, so that's vowsy. It was in 2004, passed in 2004. Now take note, you have there a husband who has been deprived his wife of financial support, let's say in 2000. Can a law pass in, was it 2004 or 2002? Can this subsequent law, vowsy law, 2004, can this law, vowsy law, pass in 2004, can made to punish the act of the accused committed in 2000? No, because Article 21 says, no felony shall be punishable by any penalty not prescribed by law prior to its commission. So, when the law is passed in 2004, it shall only apply to acts or omission committed after the passage of the law. No person shall be subject to criminal prosecution for any act or his until after the state had defined the crime and has fixed a penalty therefore. So that is Article 21. When shall penal law be given retroactive application? So while in Article 21, we said that a law cannot be given retroactive effect so that it will punish acts or omission committed prior to the passage of the law. But here in Article 22, it says that a penal law shall be given retroactive application. Under what circumstance? Penal laws shall have a retroactive effect insofar as they favor the persons guilty of a felony, who is not a habitual delinquent, as this term is defined in Rule 5 of Article 62 of this code, although at the time of the publication of such laws, a final sentence has been pronounced, and the convict is serving the same. So what does this mean? That a subsequent law being passed by the state for a particular crime, it can only be made applicable to actions or acts or omissions committed prior to its subsequent passage if the same is favorable to the accused. What does this mean? Let us say that the accused is charged under the RPC and here comes a new law amending that act of the accused punished under the old law, and the new law actually punishes that act or omission, and it carries with it a lighter penalty. Is it favorable? Yes. Kay lighter penalty man ang i-provide of this new or subsequent law. In Article 22, it can be given retroactive effect because it favors the persons guilty of the felony. However, the same does not apply if the accused is a habitual criminal. In other words, even if the subsequent penal law is favorable to the accused, it cannot be given retroactive application even if favorable to the accused if he is a habitual delinquent. Same thing with the one already serving sentence. So kung sa new law, lighter ang penalty, unya na-serve out na niya ang penalty based on the new law, then it still be given effect to him. Okay? Not only that it applies only to those cases that are still pending trial, but it shall also be applicable to accused who is already serving sentence. So except when the accused is habitual criminal or the new law provides otherwise, Meaning to say, the new law expressly provides that it cannot be given retroactive effect to pending or existing causes of action. So that is actually included in the exception. So what do we mean by Article 22 is actually the same is not applicable to the RPC provision but to the special penal laws that are subsequently passed after the RPC. So what then is the effect of repeal of penal laws? Okay, again, you have there charge against you under an old law, and then here comes a new law, a special penal law, amending the old law. So what would be the effect? If this new law or subsequent law totally repeals the old law ceases to exist. Meaning to say, it ceases to be a law, it is deemed a dead law. Okay? So if trial is still pending, the effect is that the case against the accused shall be dismissed. Why? Because the law punishing the act to which he is currently under trial cease to exist as a law. So the case will be dismissed. Now, what if the accused is already serving sentence? The convict will be discharged because there is no more law that punishes the act or omission to which he was previously convicted and serving sentence. Now, what if the new law actually did not totally repeal the old law? So meaning to say, criminal liability of the accused subsists. Under what circumstance? The provisions of the former law are reenacted by this new or subsequent law. In other words, while there may be a new law or a subsequent law that is being passed, however, this subsequent law merely reenacted the provisions of the old law to which you are charged. So meaning to say, it is as if that there is no effect to the charge you are currently under trial or serving sentence. Now, criminal liability likewise subsists if the repeal of this subsequent law is by implication only. What do we mean by implication? It's not express. It's just an implied. And we have there the principle in statutory construction that implied repeal is not favored. So, criminal liability subsists. Same thing if that new law or subsequent law, there is a saving clause to the new law, that the provisions of this law does not apply to pending causes of action. Meaning to say, even if the new law provides for an amendment or repeal of the old law to which you are charged, but because of the presence of the saving clause that it does not apply to pending causes of action, then it shall not affect your criminal liability. Your criminal liability subsists. While we talk about retroactive application of penal law if the same is favorable to the accused who is not a habitual delinquent, repeal actually does not affect the jurisdiction of the court. In People versus Romualdo, the court ruled that there is no retroactive effect of penal laws as regards jurisdiction of the court. The jurisdiction of a court to try a criminal action is to be determined by the law in force at the time of instituting the action and not at the time of the commission of the crime. Again, when you will be filing or instituting the action, the law in force at the time of the institution of the action shall be the basis for purposes of determining the jurisdiction of the court. And once the court has acquired jurisdiction over the person of the accused, the subject matter, and over the territory, meaning to say, he has acquired jurisdiction, he has validly exercised jurisdiction. The same cannot be taken by that court until the case is fully terminated. What penalty may be imposed for the commission of a felony? Article 21 provides only that penalty prescribed by law prior to the commission of the felony that may be imposed. Meaning to say, you have there a prior law defining and punishing a particular act or omission. So, he can only be punished to that particular law being passed prior to the commission of the felony. In Article 366, felonies are punishable upon the laws in force at the time of their commission. Okay, at the time of their commission. But the penalty prescribed by law enacted after the commission of the felony provided under Article 22 may be imposed if it is favorable to the offender with a further qualification that he is not a habitual criminal. Article 23, pardon. Pardon given by the offended party, what would be the effect? A pardon of the offended party does not extinguish criminal action except as provided in Article 344 of the Code, but civil liability with regard to the interest of the injured party is extinguished by his express waiver. Take note and remember that when a person commits a crime, there are actually two parties that are being injured by his act or omission. First, you have there the injury that he caused to the state, and the second is to the private offended party. Now, in Article 344, if the person extended pardon to the offender, it does not affect his criminal liability. It does not extinguish his criminal action. But you have there, except as provided in Article 344. What does this mean? Will it extinguish his criminal liability under Article 344? No. It only talks about bar to prosecution, but not a mode of extension of criminal liability. What is Article 344? Prosecution of crimes of adultery, concubinage, seduction, abduction, and acts of lasciviousness. So these are actually the crimes that cannot be prosecuted de officio, meaning to say it can only be instituted at the instance of the offended spouse as far as adultery and concubinage is concerned, and the private offended party as far as seduction, abduction, and acts of lasciviousness is concerned. If the author is talking about rape, so disregard that one because rape has been reclassified as crimes against persons already under Title 8 and is not included in crimes against chastity. So it's not, it is outside the purview of the application of this article is concerned. Now, let us say that the offended spouse has pardoned the offender spouse in adultery and concubinage. If the spouse there, the offended spouse, extended pardon to the offender spouse, the law says to be effective as a bar to prosecution, he has to extend that pardon, express pardon, to both the offender spouse as well as the paramour in adultery. In concubinage, the offender spouse and the concubine, both of them has to be extended pardon by the offended spouse prior to its institution so that the same shall bar its prosecution. It is not effective if the offended spouse only extended pardon to the offender spouse. Buot pasabot ang iyang ikiha, ang kabitra or ang uyabra in adultery and concubinage. That is ineffective because if both are still alive, both has to be prosecuted. And if he wants to extend pardon, both has to be pardoned. And that should be done prior to the institution of the criminal action to bar prosecution. What is the effect if the prosecution or the institution of the action has commenced? The effect would be it is not a bar to prosecution, meaning to say we can still proceed with the criminal institution, but if you say, could we still secure conviction? That is another thing, okay? That is another thing. But basically, pardon given after the institution of the criminal action, it would not bar the prosecution of the parties. How about seduction, abduction, and acts of lasciviousness? Same thing. It must be done prior to the institution. Okay. Now, how about to elaborate this last sentence? But the civil liability with regard to the interest of the injured party is extinguished by his express waiver. So this is applicable not only to Article 344. In any other case, not only in 344, if you have their pardon extended by the private offended party, that pardon works to extinguish the civil liability of the accused as against to the interest of the injured party. So a crime committed is an offense against the state. In criminal cases, the intervention of the aggrieved party is limited to being witnesses for the prosecution. That's why, as a general rule, the criminal case proceeds even if the private complainant is no longer interested because it is a crime against the state. That's why in a criminal case, the plaintiff there is the people of the Philippines. Now, how about if the pardon is extended by the chief executive? That's another story because the chief executive can extend pardon to the offender and it can be extended anytime provided there is already conviction on the part of the accused. Okay, what I mean anytime is that it is not required that prior to institution of the criminal action. In fact, the law requires that the accused has been convicted already by the court before the chief executive can extend pardon to the accused. Because prior to that, there is no one that the chief executive can pardon because there is no one that has been convicted yet. In fact, prior to conviction, di man gani na mo angkon si offender na kasala siya. So, kung wala na siya kasala, nganong pasayloon man. So, as a requirement, there must be prior conviction that is required. So, what does except as provided in Article 344 of this code means? That the offended party in the crimes of adultery and concubinage cannot institute criminal prosecution if he shall have consented or pardoned the offenders. The pardon here may be implied as continued inaction of the offended party after learning of the offense, meaning to say, presumably, he had pardoned the parties because of his inaction, and then to be effective requires that both offenders has to be pardoned by the offended party. In crimes of SAA, seduction, abduction, or acts of lasciviousness, there is no criminal prosecution if the offender has been expressly pardoned by the offended party, or in her incapacity, her parents, grandparents, or guardian, as the case may be. The pardon here must be expressed. Now take note that this substitution by the parents, grandparents, or guardians are exclusive under this order. So after the offended party, you have here the parents first. Then in capacity of the parents, grandparents, and then the guardian in that particular order. Again, before the institution of the criminal prosecution. But you have the exception, marriage. Why? Because in marriage, it is not required that the same be done before the institution of the criminal prosecution. In fact, it can happen anytime thereafter. What does it mean? That if the offender entered into a valid marriage while the case is pending, then that would be a ground for the dismissal of the case. If the accused entered into a valid marriage with the offended party and he is already serving sentence, then that would terminate the service of his sentence. And take note, in SAA, seduction, abduction, acts of lasciviousness, the marriage of one of the offender, if in case there are many offenders or the offender has co-accused in a particular case, it also worked to benefit his co-accused or the accomplices or the accessories, as the case may be. They can benefit out from that marriage. Do not be confused with rape, because rape is no longer classified under crimes against chastity. It has been transferred to Title 8 as crimes against person. So if there is marriage between the offender and the offended party, in rape, it is applicable only if the charge against the accused is for simple rape only. It is not rape, the charge is not complex crime like forcible abduction with rape or special civil action, as the case may be. Applies only to simple rape. And the same is effective only between the offender who entered into a valid marriage of the offended party. In other words, it would not work to benefit his co-accused in rape. Now, in Article 24, actually enumerates to us instances, but they are not considered to be penalties, but mere preventive measures only. And what are they? If you are arrested and temporary detention of accused persons, as well as the detention by reason of insanity or imbecility or illness requiring their confinement in a hospital. Now, to illustrate this one, we can take that example on those COVID patients or COVID positive individuals that they were forced to be isolated away from their family and put in the place that let's say that there is a little suffering because according to them the physical condition is not that it's not that nice, it's not that nice. They cannot even, they do not even have the amenities. So we can have that, treat that the same way as paragraph 1. While they are there in isolation, they were not required to live there at will, but that is not a penalty, but only a preventive measure in the exercise of the state of its right to police power. Okay, so same thing with paragraph 1. Commitment of a minor to any of the institutions mentioned in Article 80. Now, the law does not, the law prescribe minors to be put into prison. If you check now, by virtue of the passage of RA 9344 as well as its amendment, it is prohibited from detaining or putting the minor in the penal institution. So where is he placed? In those, let's say like in Cebu City, you have their Operation Second Chance. We have here RRCY in Argao, the Regional Rehabilitation for Youth, and other institutions that cater the commitment of these minors. So these institutions are not actually penal institution, but they are the bahay pag-asa for that matter, whatever they call it. So those are not considered to be a penalty. You have to remember that if a CICL found to be liable by the court for the charge he commits, can avail of suspended sentence. So di gid siya masulod sa prisuhan. Now how about if he commits a violation? Dili gihapon siya isud sa prisuhan, but on those places that, let's say the RRCY, wherein he will be put there for reformation to prepare him for his reintegration. You also have their suspension from the employment of public office during trial or in order to institute proceeding. So basically, during trial or in order to institute proceeding, so we are referring to preventive suspension. So during that period, you are prohibited from reporting to the office to prevent you or deter you from influencing possible witnesses to the charges against you. So that is not a penalty, but merely a preventive measure. Fines and other corrective measures in the exercise of their administrative disciplinary powers of the superior officials may impose upon their subordinates. So if you have there a violation or infraction of the rules and regulation of your office, whether it be public or private, and you were required to pay a fine, so that is not a penalty to speak of, but preventive measures only in the exercise of disciplinary power of your superior to the subordinate. You also have there deprivation of rights and the reparation which the civil law may establish in penal form. So they are not considered to be penalty. Why? Because they are not imposed as a result of judicial proceedings. There is only, in short, there is only a penalty if there is a judicial proceeding that was undertaken, and at the end of the trial, you were found criminally liable of the charge against you, hence a penalty shall be imposed as a result of judicial proceeding. That ends chapter 1. So how do we classify penalties? Chapter 2. Penalties are classified in the following. You have their principal penalties. Okay, principal penalties, they're classified into capital punishment. And when we say capital punishment, we are referring to death. And other afflictive penalties that includes reclusion perpetua, reclusion temporal, perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, and prison mayor. So these are the capital and afflictive penalties. We can classify further the penalty into correctional penalties, and it includes prison correccional, arresto mayor, suspension, and destierro. And lastly, we have here the light penalties consisting of arresto minor, public censure. And common to the three preceding classes, you have there the fine and ban to keep the peace. So those are the principal penalties. From principal penalties, we have there the so-called accessory penalties. What are they? Perpetual or temporary absolute disqualification, perpetual or temporary special disqualification, suspension from public office, right to vote and be voted for, and suspension from the practice of profession or calling, civil interdiction, indemnification, forfeiture or confiscation of instruments and proceeds of the offense, payment of the cost, and these are exclusive. What do we mean by this? That the court, after the rendition of judgment, can only impose penalties as provided under Article 25. That's why you have there, these are exclusive. The court cannot impose any other penalty not provided under Article 25 as an example. A sentence of 5 years in bilibid, penalty of hard labor, penalty of life imprisonment, penalty of 1,000 whips, penalty of stoning or to be beaten by ants, or penalty by hanging. Why? Because these are not provided under Article 25. Now, you might be asking, but we have a penalty of life imprisonment fiscal as far as penal laws is concerned. Yes, under special penal laws. But if the charge against the accused is defined and punished under the revised penal code, the penalty that can be imposed by the court are only those penalties provided under Article 25 of the code. So we can further classify penalty according to its divisibility. Divisible penalty are penalties that have fixed duration and are divisible into 3 periods: the maximum, medium, and minimum. And what are these divisible penalties? Reclusion temporal, prison mayor, prison correccional, arresto mayor, and arresto minor. The indivisible penalty you have here: death, reclusion perpetua, perpetual absolute or special disqualification, or public censure. I think I missed one. I just have to go back. Here, about the perpetual or temporary absolute or special disqualification, you might be asking, is it not that those penalty are afflictive penalties and are principal penalties? In other words, this perpetual or temporary absolute or special disqualification could either be a principal penalty or an accessory penalty. It depends upon how the court would impose these penalties. So let's go back to the further classification. So we're done with the divisibility. You have here classification according to subject matter. It is corporal if the penalty is death. It is deprivation of freedom, and it includes the reclusion temporal, prison mayor, and prison correccional, reclusion temporal and perpetua, prison mayor and prison correccional, arresto mayor, arresto minor. So those are deprivation of freedom. Destierro is classified as a restriction of freedom. Why? Because destierro is not to be executed inside the penal institution. You are just there outside roaming around, only that you are prohibited from entering the prohibited area. And then you have their deprivation of rights, consisting of disqualification, and suspension. And then lastly, you have their pecuniary if the penalty is fine. And then according to gravity, it is classified as capital, afflictive, correctional, and light. So how about if the penalty is fine? How do you classify fine? Fine is considered to be afflictive if it exceeds 1.2 million. If the fine imposed by the court does not exceed 1.2 million but is not less than 40,000, this same is a correctional penalty. But if it is less than 40,000 pesos, the same is classified as a light penalty. So how to impose? Either as an alternative penalty or as a single penalty. As an alternative penalty, it can be done this way. If the accused is being charged under Article 144, and Article 144 provides that a person shall be punished if he disturb the proceedings with a penalty of Arresto Mayor or a fine ranging from 200 to 1,000 pesos. So the discretion is given to the Honorable Court what penalty he shall impose upon the offender, either the penalty of imprisonment of Arresto Mayor, or he will impose only the penalty of fine to the accused. Now, as a single penalty, the law usually provides that the accused shall be punished with a fine of 200 to 6,000. Now, if you notice, there is that duration on the, no, not duration, but a range as far as the penalty is concerned. So, as to the actual fine that shall be imposed, the discretion is given to the court on what the final and the actual fine that the accused shall be made to pay for as long as it is within the range provided for by law. And what do we mean by penalties cannot be imposed in the alternative? Now take note, di ba, it can be imposed in the alternative, but how shall the court actually impose the penalty? Because it is required that it must be certain, it must not be imposed in the alternative. The Court of First Instance of Quezon found Alejandro Mercadejas guilty of violation of RA number 145 and sentenced him to pay a fine of 1,000 or to suffer an imprisonment of 2 years and to pay the cost. So this is the judgment of the court. The High Court ruled the law does not permit any court to impose a sentence in the alternative, the duty being to indicate the penalty imposed definitely and positively. So if this is the actual penalty imposed by the trial judge or the trial court, and the High Court says, no, that is not accurate because it should be certain, it should not be imposed in the alternative. Now, the trial court should have made the decision as follows. Finding the accused Alejandro Mercadejas for violation of RA number 145, he is hereby sentenced to pay a fine of 1,000 and to pay the cost, okay? 1,000. So at least that is certain that the penalty imposed upon him is fine of 1,000. Or the court would say, finding Alejandro Mercadejas guilty of violation of RA 145, he is hereby sentenced to suffer an imprisonment of 2 years and to pay the cost. In other words, the court, when imposing the actual penalty upon the accused, he must not do it in the alternative. And he will be now giving the discretion on the part of the accused on what penalty he wants. No, he must impose therein what is the penalty to be imposed upon him. He should exercise his discretion in choosing among the alternative on what would be the actual final penalty to be imposed upon the accused, provided the same is provided within those penalty provided for by law for that particular felony. Now, if you notice, you have there the fine of exactly 40,000. 40,000. So is there a conflict between Article 9 classifying the felony, between Article 26 classifying the penalty? Because a fine of exactly 40,000, if the question of the examiner is the classification of felony or what felony is committed by the accused, and the fine is exactly 40,000. So as far as classification of felony is concerned, the provision of Article 9 prevails, so that is a light felony. If the question is classification of penalty, hence the fine exactly 40,000 is classified as correctional penalty, Article 26 prevails. Okay, that ends Chapter 2 of Title 3. Now, by the way, considering that the topic on penalty is very long, we will have it in 2 parts, and we are now doing the first part. Okay, let's proceed with Chapter 3, Section 1 on the duration of penalties. So when we say duration, we are talking about the range or the period covered in a particular penalty. So reclusion, the penalty of reclusion perpetua, its duration is 20 years and 1 day to 40. If it is reclusion temporal, its duration is 12 years and 1 day to 20 years. Prison mayor and temporary disqualification, the duration shall be 6 years and 1 day to 12 years, except for disqualification if the same is imposed by the court as an accessory penalty, then the duration of the disqualification imposed as an accessory penalty is the same as that of the principal penalty. Remember, it can either be imposed by the court as a principal penalty and accessory penalty. To illustrate, if the crime charged against the accused and to which he was subsequently found guilty by the honorable court is homicide, so he was imposed a penalty of reclusion temporal, where the duration is 12 years and 1 day to 20, and the accessory penalty of temporary disqualification. Example. So what would be the duration of the temporary disqualification? Here it says 6 years and 1 day to 12 years. However, in that particular set of facts, considering the disqualification was imposed by the court as an accessory penalty to the accused, to which his principal penalty is reclusion temporal with a duration of 12 years and 1 day to 20, then the disqualification imposed by the court, the accessory penalty of disqualification imposed by the court, shall take the duration of the principal penalty, which is the same as that of reclusion temporal. How about prison correccional, suspension, and destierro? The duration shall be 6 months and 1 day to 6 years. Except for suspension, same with disqualification, if the same is imposed as an accessory penalty, the duration shall be that of the principal penalty. How about arresto mayor? The duration shall be 1 month and 1 day to 6 months, and 1 day to 30 days as far as arresto minor is concerned. Ban to keep the peace. The ban to keep the peace shall be required to cover such period of time as the court may determine. Now take note that ban to keep the peace is not specifically provided as a penalty for any felony and therefore cannot be imposed by the court. What do we mean by this? That later on, when you will be having your book 2 of the revised penal code, to which you will be studying specific felonies with its elements of the crime and prescribed penalty for these felonies defined and punished under the revised penal code, nowhere in the code where you can see that bond to keep the peace are imposed by the law as a prescribed penalty for any offense or felony. And considering that the same was not imposed as a prescribed felony for any offense, not prescribed as a penalty for any felony, then the court cannot impose this particular penalty. Okay? So remedy, if you will be elected come May 2022 as a representative of your legislative districts, you can or you may file an amendment to any of the felonies in the revised penal code that you want this bond to keep the peace to be the prescribed penalty. You can actually do that. That be your remedy. But for now, considering that there is no felony to which bond to keep the peace is the prescribed penalty, then the court cannot impose the same, though the same is provided under Article 25 of the Code. Article 28, rules in computing. If the offender shall be in prison, the term of the duration of the temporary penalties shall be computed from the day on which the judgment of the conviction shall have become final. If the offender be not in prison, the term of duration of the penalty consisting of the privation of liberty shall be computed from the day that the offender is placed at the disposal of the judicial authorities for the enforcement of the penalty. The duration of the other penalties shall be computed only from the day on which the defendant commences to serve sentence. So what do we mean by this? Now take note that the first paragraph says, if the offender shall be in prison. So this is a scenario wherein the accused is undergoing preventive imprisonment because he was not able to post bail, or the case to which he is charged is non-bailable. So Article 28, first paragraph provides that the term of the duration of the temporary penalty shall be computed on the day to which the judgment of conviction shall have become final. Why? Because while the case is pending or while the case is undergoing trial, though you are there inside the penal institution, you are not yet serving sentence. You are not yet serving sentence, but what you are undergoing is still a preventive imprisonment. When are you deemed to be considered to be serving sentence? That is that moment that your judgment of conviction shall have become final. For example, if you are convicted today by the Honorable Court, you still have there the 15-day period within which to file an MR or an appeal. If not, then after the 15-day period, that is the only time that your conviction becomes final. So on the 16th day, that means to say that you are now actually serving sentence. So prior to that one, that you call that one as preventive imprisonment only. So if the offender be not in prison, so that moment that you are placed under the disposal of the judicial authorities, so let us say that you were able to post bail and then you were found guilty by the Honorable Court and your judgment of conviction becomes final already. So of course you have to surrender yourself to the authorities, or you will be arrested just in case because you did not present yourself during the judgment. So that moment that you are placed at the disposal of the authorities for the enforcement of your penalty, then that is the only day as well that you are commencing to serve your sentence. As a recap, when the offender is in prison, the duration of temporary penalties is from the day on which the judgment of conviction becomes final. In other words, while you are serving preventive imprisonment, that and you are found guilty by the honorable court, you are deemed to commence serving your sentence after your conviction has become final. How about the temporary penalties or the accessory penalties? You are only deemed to commence serving them when your conviction has become final. Same with the next paragraph. If not in prison, you are deemed to serve your penalty consisting of deprivation of liberty the moment you are placed at the disposal of the the judicial authorities for the enforcement of the penalty, consisting of both the deprivation of liberty, and that would actually include your accessory penalty. The duration of other penalties is from the day on which the offender commences to serve his sentence. Especially if you have there, let us say, to illustrate lang, before, after conviction of the MTC or the first level, you can actually post bail if convicted and you want to appeal your case. So pending appeal to the RTC, you can avail of bail. In the RTC, the moment that you, so kung katong nag-bail ka, wala pa ka at the disposal of the authorities. So the moment na gi-appealed ni appellate court ang imong conviction with the trial court, then of course you have to serve your sentence. So the moment that you you are placed at the disposal of the judicial authority for the enforcement of your penalty nga gi-upheld ni appellate court, then that is the moment you are deemed to commence the service of your sentence. Same thing with katong wala naka-bail or RTC jurisdiction, you are convicted and then the court did not allow you to post bail pending appeal. So while the case is still pending appeal, it does not mean that you are now already commencing to serve sentence. You are not yet commencing the service of your sentence because your conviction is not yet final. It only commences the moment your conviction has become final. Mauna na siya ang service of sentence prior preventive imprisonment. So what is the use there of the preventive imprisonment? Can we make use of that? So you have there RA 10592 that amends Article 29 of the Code, and it provides that offenders or accused who have undergone preventive imprisonment shall be credited in the service of their sentence, consisting of deprivation of liberty with the full time during which they have undergone preventive imprisonment if the detention prisoner agrees voluntarily in writing after being informed of the effects thereof and with the assistance of counsel to abide by the same disciplinary rules imposed upon convicted prisoners. So let's stop from there first. In other words, your preventive imprisonment, the imprisonment that you have undergone prior to the finality of your conviction, wherein that is considered to be a preventive imprisonment, Article 29 as amended by RA 10592 provides that that preventive imprisonment shall be deducted full time to the penalty imposed upon you by the court, provided you agree voluntarily in writing to abide by the same disciplinary rules imposed upon convicted prisoners. Take note, you have their assistance of counsel. However, even if you agree voluntarily in writing to abide by the same disciplinary rules imposed upon convicted prisoners, the same does not apply or you cannot be credited full time of your preventive imprisonment if you are a recidivist or have been convicted previously twice or more times of any crime. And when upon being summoned for the execution of their sentence, they have failed to surrender voluntarily. So this is the instance in paragraph 2 nga you are able to post bail and you were convicted by the court and your conviction has become final, you failed to surrender voluntarily. Now, how about what do we mean by this to abide by the same disciplinary rules? Now, take note that penalty imposed in the penal institution is commensurate of the gravity of the offense. It has purpose of reformation or correction. It's because in the penal institution, you have their rules and regulations that are done by the imposed by the BJMP, the Bureau of Jail Management and Penology. There are activities there. There could be life skills, alternative learning that you can use. In fact, na sila yung mga credit paman gani. If you are there, you act there as a teacher, or let's say because you are a nurse and you are there undergoing their, let's say, lectures on them, on how to prevent COVID, meaning to say you are there, aside from being there inside the penal institution, you are also doing something productive and you are extending these things to others. Actually, it's part of their policy that you will be given credit to your efforts. You have their exercises and discipline imposed upon them to maintain decorum inside. So if you do not agree with them, meaning to say, nagsige ra jud kag kaon katulog dito, di ka mo participate because you did not agree voluntarily in writing that you will be abiding the same disciplinary rules as that of those to be imposed to convicted prisoners. So what would be the effect to your preventive imprisonment? The law says that you shall be credited only 4/5 of the time during which the person there undergone preventive imprisonment. Now, credit for preventive imprisonment for the penalty of reclusion perpetua shall be deducted from 30 years. Remember, the duration of reclusion perpetua is from 20 years and 1 day to 40. So for purposes of deduction of this preventive imprisonment, or whether it is full-time or 4/5, the same shall be deducted from 30 years and not 40 years. Whenever an accused has undergone preventive imprisonment for a period equal to or more than the possible maximum imprisonment of the offense charged to which he may be sentenced, and his case is not yet terminated, he shall be released immediately without prejudice to the continuation of the trial thereof or the proceeding on appeal if the same is under review. Computation of preventive imprisonment for purposes of immediate release under this paragraph shall be the actual period of detention with good conduct time allowance. What does this mean? That there are instances that the preventive imprisonment of an accused, considering the length of time to which the court conducted the trial of the against the accused, especially now that we have COVID for almost 2 years, the trial before the courts are actually dragging. So the court ruled that the law provides that if the same shall be equal to the possible maximum penalty to which the law imposes upon the felony to which you are charged, you just have to manifest to the court so that you will be released immediately. Okay, released immediately. But it doesn't mean that the trial shall be terminated or it shall end the trial or the appeal to which you are still availing at that time. While you will be released immediately, the trial shall continue or the appeal shall proceed if there is one. What is the purpose? Because at least if at the end of the day, the trial court would acquit you, at least you will be able to save your clean name. You will not taint your name with that bad record of being convicted of an offense. At least clean name. So that's the reason why the trial shall continue, or if there is that is already on appeal, the appeal shall continue with the hope that on appeal, the conviction will be reversed, so there would be no criminal record that shall attach to your name. Now, let us say nga na convicto gyud ka, either after trial or on appeal, mapriso pa ba ka? No more. You have served already, mo bitong gi-release ka immediately because you have undergone preventive imprisonment equal to or more than the possible maximum imprisonment of the offense. So, for example, the crime charge against you is, let's say, slight physical injury. Wa makakapiyansa. So, while the trial is ongoing, dito sa kasulod prisuhan, unya kay na COVID man, and then the courts were physically closed. So, unsa naman kakaduga-dugayon dito? The duration of arresto minor, which is the prescribed penalty for slight physical injury, is 1 day to 30 days. Unya 31 kaadlaw na ka sa prisuhan. You seek for your immediate release, but the trial shall continue. Kung nakonbikto ka, mana na serbisyuan na nimo. Now, take note of the last sentence. Computation of preventive imprisonment for purposes of immediate release under this paragraph shall be actual period of detention with good conduct time allowance. GCTA. In other words, aside from the fact nga kato akong giingon ganina nga makredit bitaw ka sa imuhang, di ba, you have the preventive imprisonment. So, i-deduct siya full time or 4/5 sa imuhang penalty to be imposed. Now, take note that you have there the so-called GCTA. The GCTA is actually a credit that shall be given to you for every month that you are there inside. Meaning to say, naa kay credit. Meaning to say, kung ang 30 ka-adlaw plus the credit, mas minus pa yun na siya. Dili yun na siya actually 30 days. Now, nag-mention sa ko ganina nga nag-lecture ka dito inside or nag-teach ka dito baron og cooking because you are a chef. So, inside the penal institution, you teach the other inmates there how to cook. Those efforts that were done to you with those kinds of activities, additional credit or special time allowance would actually be given to you on top of your GCTA, and all of this has to be deducted from your penalty to be imposed. It provided, however, that if the accused is absent without justifiable cause at any stage of the trial, the court may motu proprio order the rearrest of the accused, provided finally that recidivists, habitual delinquents, escapees, and persons charged with heinous crimes are excluded from the coverage of this act. So in other words, while gi-release ka immediately because you have undergone preventive imprisonment equal to the possible maximum penalty to be imposed upon you, if the court requires you to be present during trial and you failed to appear, that is without justifiable cause, the court can order your rearrest. Okay? So, because that failure to comply the order, it's actually a contempt against the court. Now, last sentence, in case the maximum penalty to which the accused may be sentenced is destierro, he shall be released after 30 days of preventive imprisonment. Take note, destierro has a duration of 6 months and 1 day to 6 years. But why is it that after 30 days of preventive imprisonment, he has to be released? Why? Because destierro supposedly should not be executed inside the penal institution. Remember, you are just prohibited from entering the prohibited area, meaning to say wala ka inside the penal institution. So just in case the penalty of the felony to which you are charged is only destierro, then preventive imprisonment of 30 days is enough and you shall be released immediately. So when is there preventive imprisonment? Either the charge against you is non-bailable, or if it is bailable, you cannot furnish the required bail. So let's apply. A was accused of homicide punishable by reclusion temporal because he could not put up bail of 60,000. He was detained pending his trial, which lasted for 2 years. If after trial, A was found guilty and sentenced to an indeterminate penalty of 6 years and 1 day to 12 years and 1 day, the full of A's preventive imprisonment of 2 years shall be deducted from the 12 years and 1 day. If he agreed voluntarily in writing before or during the time of his temporary detention to abide by the same disciplinary rules imposed upon convicted prisoners. But if A did not agree to abide by the same disciplinary rules imposed upon convicted prisoners, only 4/5 of the 2 years during which he has undergone preventive imprisonment will be deducted from the 12 years and 1 day. So what is 4/5 of 2 years? That would be around 1 year, 7 months, and 6 days. So kung ni-agree pa to siya, so 2 years, that would be 24 months. Since he did not agree, so only 4/5. 1 year, 7 months, and 6 days. Compare. A was accused of a violation of Article 143 of the RPC. The penalty provided for in that article is prison correccional or a fine of 200 to 2,000 or both. During the pendency of his trial, A was detained for 10 days. Having been found guilty, he was sentenced to pay a fine of 2,000. Can A successfully claim that his fine should be reduced because of his preventive imprisonment for 10 days? The answer is no, because his sentence that does not consist in deprivation of liberty. Okay? His sentence does not consist in deprivation of liberty. So remember, the penalty imposed by the judge to him is only to pay a fine of 2,000. So that is not compatible with deprivation of liberty, which is imprisonment. So dili ka pwedeng mohangyo ni 2,000 nga himuong 1,000 kay naka preventive imprisonment ka. Now, distiero. What if distiero is the penalty imposed upon you? It actually constitutes deprivation of liberty, though in the earlier article, it is classified as restriction only of liberty. But take note that in distiero, there is that preventive imprisonment of 30 days. So it can actually be reconciled. Deprivation of liberty actually includes restriction of liberty. Okay, so he shall be credited of preventive imprisonment just in case the penalty imposed upon him is distiero. So let us say that he was able to undergo preventive imprisonment of 10 days. Then thereafter, he was able to post bail. Then after trial, he was convicted. He was sentenced to distiero. So he can claim the 10-day preventive imprisonment to be deducted from the duration of the distiero imposed upon him. Effects of the penalties according to their respective nature. Article 30. The penalties of perpetual or temporary absolute disqualification for public office shall produce the following effects. So if this is the penalty imposed upon you, the effect would be you will be deprived of the public office and employment to which you hold or may have held even if conferred by popular election. Okay, so you will be deprived of the public office. You will also be deprived of the right to vote in any election, included to be elected to such office. Okay, that is the effect of the perpetual or temporary absolute disqualification. Perpetual for life, temporary, it has duration. And the absolute disqualification would include the following: deprivation of the public office you hold, deprivation of your right to vote and be voted, deprivation of the offices or public employments you are having, and in case of temporary disqualification, such disqualification is comprised in paragraphs 2 and 3 of this article shall last during the term of the sentence. So what we are referring to, the right to vote and be voted, and the right to office. If it is only temporary disqualification, temporary absolute disqualification, the same shall last during the term of the sentence, because you have there perpetual or temporary absolute disqualification. So the 2 and 3, if it is temporary absolute disqualification only, shall last during the term. If not, because it is perpetual, then it is for life, and it shall include 1, 2, 3, and the 4 there, loss of all the rights to retirement pay or other pension for any office formerly held. That includes the perpetual or temporary absolute disqualification. Okay, absolute, consisting of 1, 2, 3, 4. 31, perpetual or temporary special disqualification. Special disqualification. And what shall it include? Deprivation of the office, employment, profession, or calling, and disqualification for holding similar office or employment either perpetually, if it is perpetual, or during the term, if it is only temporary. According to the extent of the disqualification, this same is left at the discretion of the court. So, while the absolute disqualification, naa siya paragraph 1, 2, 3, 4, in the special disqualification, only paragraphs 1 and 2 is included in the special disqualification, be it perpetual or temporary. 32. It is somewhat a reiteration of the special disqualification, but 32 is specific only for the exercise of the right of suffrage. Okay, perpetual or temporary special disqualification for the exercise of the right of suffrage shall deprive the offender perpetually or during the term, if it is only temporary, according to the nature of said penalty, of the right to vote in any popular election or to be elected. Moreover, the offender shall not be permitted to hold any public office during the period of his disqualification. So, included ra gyud siya sa previous articles, gi-separate lang sa gyud pud siya. Same with 33. On the exercise of profession or calling, right to suffrage, and this 33 is only suspension of the exercise of this enumeration here. The suspension from public office, profession, or calling, and the exercise of the right of suffrage shall disqualify the offender from holding such office or exercising such profession or calling during the term of the sentence. Suspended lang. Suspended. The person suspended from holding office shall not hold another having similar function during the period of his suspension. How about the penalty of the accessory penalty of civil interdiction? If the person is imposed the accessory of civil interdiction, it shall deprive him during the time of his sentence of the rights of parental authority. Okay, he will be deprived of guardianship, either as to the person or property of any ward, and even his marital authority. Okay, so kung superior kay si husband before, because of the civil interdiction, he will be deprived that marital authority to the wife. Right to manage his property and the right to dispose of such property by any act or any conveyance inter vivos. So meaning to say, you will be incapacitated. What is the thing that the person being adjudged to be suffering from civil interdiction is? He can dispose or convey his property but only mortis causa. Okay? This is the only thing that he can do while he is under or suffering from civil interdiction. He can make a testamentary disposition, because testamentary disposition shall take effect only upon his death. That's why it is mortis causa, upon his death. But during his lifetime, these are all his deprivation. Again, this is the only thing that he can do, to make a testamentary disposition to be effective only mortis causa. So he can make his will. In 35, effects of bond to keep the peace. It shall be the duty of any person sentenced to give bond to keep the peace to present two sufficient sureties, who shall undertake that such person will not commit the offense sought to be prevented, and that in case such offense be committed, they will pay the amount determined by the court in the judgment or otherwise to deposit such amount in the office of the clerk of court to guarantee said undertaking. In other words, these are done for purposes of, let's say, wala siya og security money or security bond to prevent you from doing something. And in case you violate that that agreement, or there is violation of the if you commit those prohibited acts, let's say, to keep away from this particular person or to keep him safe, you violate that agreement, then you will be required to pay the amount determined by the court. The court shall determine according to its discretion the period of duration of the bond. Should the person sentenced fail to give the bond as required, he shall be detained for a period which shall in no case exceed 6 months if he shall have been prosecuted for a grave or less grave felony, and if it is only a light felony, not to exceed 30 days. Article 36, pardon. But this one, we are referring to the pardon extended by the chief executive. A pardon shall not work the restoration of the right to hold public office or the right of suffrage unless such rights be expressly restored by the terms of the pardon. A pardon in no case exempt the culprit from payment of the civil indemnity imposed upon him by the sentence. Now, what does this mean? That the pardon extended by the chief executive, in fact, I've mentioned earlier that there must be conviction first of the offender. If a pardon is extended to him after he is convicted, it will not work to restore the accessory penalty unless the pardon expressly provides that his right to hold public office, his right to suffrage shall be restored. Okay? General rule, if silent si pardon, ang pardon lang ni Chief Executive, ang penalty consisting of deprivation of liberty. It does not include the accessory penalty. So, as an exception, it will only be restored if the same was likewise expressly provided in the pardon extended by the chief executive. Now, the next paragraph. While the convict may escape the service of his sentence by virtue of the pardon extended to him by the chief executive, that pardon does not exempt him from paying the civil indemnity, meaning to say, he has to pay his civil liability, his civil obligation to the private offended party. Now, I put here that we should compare this with amnesty, because if what is extended by the chief executive is amnesty as compared to pardon, pardon does not work to restore the right to hold public office or the right of suffrage. However, if the same is amnesty, it will restore everything as if the person, the offender, is a new man. It erases the vestiges of the crime, of the criminal act done by the accused. It erases everything. So that is amnesty as compared to pardon. So a pardon shall not restore the right to public office, right to suffrage, except when expressly restored by the terms of the pardon. It shall not exempt the culprit from payment of the civil indemnity. Pardon cannot make an exception to the rule. Okay? Pardon granted in general terms does not include accessory penalty. That's why kaning accessory to be erased as well, it has to be expressly provided in the pardon. So this is a recap on the provision of the law. So what I've mentioned earlier, that pardon can only be exercised by the chief executive after conviction. And another thing, it does not extend to cases of impeachment. It does not extend to cases of impeachment. So unsa may mapardon ni chief executive? Commission of criminal offenses, and impeachment is not a criminal proceeding. Okay. Earlier, we've mentioned of pardon by the offended party, and now we are confronted with pardon of the chief executive. So let's distinguish the two. Pardon by the chief executive extinguishes the criminal liability of the offender. Such is not the case when the pardon is given by the offended party. Remember, it only bars prosecution, and the same and it is a requirement that the same must be done prior to the institution of the criminal action. Pardon by the chief executive cannot include civil liability, which is the offender must pay. But the offended party, in case he extend pardon, it is actually a waiver of the civil liability which the offender must pay. In cases where the law allows, pardon by the offended party should be given before the institution of the criminal prosecution and must be extended to both offenders, whereas pardon by the chief executive is granted only after conviction and may be extended to any of the offenders. So that is the distinction between the two pardons. Costs. Costs shall include fees and indemnities in the course of the judicial proceeding, whether they be fixed or unalterable amounts previously determined by law or regulation in force, or amounts not subject to schedule. So to apply this one, costs are expenses in litigation. They are chargeable to the accused only if he will be convicted. And in cases of acquittal, so meaning to say the judgment of the trial court is that he is not liable, so he is acquitted. The costs are de officio. And when we say de officio, each party bearing his own expenses. So kanidi ang first paragraph that in case of conviction, chargeable to the accused, costs against the accused, these are the litigation expenses. We are referring to the litigation expenses. But if he is acquitted, then the officio, each party bearing his own expenses. Thus, of the three accused, two were convicted while the third was acquitted. Only one of the two convicted appealed. His conviction was affirmed. He was ordered to pay 1/3 of the cost. Why 1/3 of the cost? Now take note, initially tulo sila. Na-acquit man ang usa. So tulo man sila. So the cost should be divided by the three of them. Since ang usa na-acquit, the officio ang iyang cost. Silang na duhang na convict, of course, they will also have to bear the proportionate cost to them. So since they are 3 divided by 3, The one whose conviction was affirmed shall pay only 1/3 of the cost. It also did not mention about the other one either. Ni-serve siya dayon, so pay his cost as well. As a rule, no cost against the Republic. So the Republic, we're referring to the people of the Philippines. And then payment of costs is actually discretionary as far as the court is concerned. Pecuniary liability, remember the pecuniary liability, we are referring to the fine. And Article 38 provides us the order of payment. In case the property of the offender should not be sufficient for the payment of all his pecuniary liability, the same shall be met in the following order. Reparation of the damage caused, indemnification of consequential damages, fine. The fine is only number 3. Fine, what is fine? It is the penalty imposed by the court, and then the cost of the proceeding. This is applicable only if there is no sufficient property or money to which the accused can meet his obligation. So under this order, unahon og bayad ang reparation followed by indemnification. Kung naapay nahabilin, maka-impose ang court og fine, or let's say makakuha ang court og fine, pero wala na yun. Okay? So to illustrate, A was charged for robbery with violence against person after he inflicted B serious physical injury and took the latter's watch and ring worth 1,250. As a result of the physical injuries inflicted, B was hospitalized and was not able to attend his work for 1 month. For hospital bills, he paid 500. For his failure to earn his salary for 1 month, he lost 300. Do not mind the figures. We do not know what was his job. And this is only for purposes of illustration. If A, after conviction, had only a property not exempt from execution worth 1,000, it shall be applied to the payment of the watch and ring, which could not be returned because they are covered by the reparation of the damage caused, and it is number 1 in the order of payment. So pila si watch and ring? 1,250 unya. Ang iyahang property not subject for execution, 1,000. So nahurot na dito tanan. The hospital bills in the amount of 500 and the salary which he failed to earn is 300 are covered by the indemnification of consequential damages, which is only number 2 in the order of payment. So, kato unahon ang reparation of damage caused to the private offended party. Wa na ganit ta kaabot sa fine. Mauraman yun. So, what's the remedy? Mudawat na lang ba ang gobyerno nga matiway, or let's say it cannot impose upon the accused the fine to which he owes the state? Now, actually, the remedy here, because while he will not be required to pay for the moment these consequential damages, the private offended party can actually claim this later on when the financial status of the accused improve. Okay, so pwede niya paninglon. Now, let's go back to the fine. What would happen to the fine? So we have here Article 39 as amended by RA 10159. If the convict has no property with which to meet the fine mentioned in paragraph 3 of the next preceding article, he shall be subject to a subsidiary personal liability at the rate of 1 day for each amount equivalent to the highest minimum wage rate prevailing in the Philippines at the time of the rendition of judgment of conviction by the trial court, and then subject to the following rules, which will we take one by one. Now, what does this mean? Now, Article 39 applies only to the fine mentioned in paragraph 3 of the previous article, meaning to say it will not be applicable with respect to the reparation of damages. Remember, in our example, na ato'y kulang at 250, and you have their indemnification of consequential damages of the hospital bill and the unearned income that is not to be covered, or Article 39 shall not be applicable. This shall be applicable only with respect to the fine imposed upon the accused as a penalty for the crime he commit. And what does the rule provides, the law provides? The 1 day shall be equivalent to the highest minimum wage rate prevailing in the Philippines at the time of the rendition of judgment. Take note, highest minimum wage prevailing in the Philippines. It did not say highest minimum wage in Region 7 or NCR or in Manila, but prevailing in the Philippines. So if you have seen a wage order, ilang man nang gi-classify kung asa ka nga worker, NCR, sa Visayas, sa Mindanao, choose which among the following is the highest, because the law says highest minimum wage rate prevailing in the Philippines. So what would be the rules? If the principal penalty imposed be prison, correccional, or arresto, and fine, he shall remain under confinement until his fine referred to in the preceding paragraph is satisfied, but his subsidiary imprisonment shall not exceed 1/3 of the term of the sentence, and in no case it continue for more than 1 year. And no fraction or part of the day shall be counted against the petitioner. Okay, take note, if this is his penalty, the subsidiary imprisonment shall not exceed 1/3 of the term of the principal penalty imposed upon him, with the further qualification that the same shall not continue for more than 1 year. When the principal penalty imposed be only fine, the subsidiary imprisonment shall exceed. Now, balik ta. You have the principal penalty and fine. O yan, penalty. The next paragraph is applicable only if the imposable penalty is fine only, no deprivation of liberty, no imprisonment. So the next paragraph provides that in case the penalty imposed upon the accused is only fine, the subsidiary imprisonment shall not exceed 6 months. If the culprit shall have been prosecuted for a grave or less grave felony and shall not exceed 15 days, if for a light felony. And when the principal imposed is higher than prison correccional, meaning to say the principal penalty imposed upon the accused is, let's say, prison mayor, di ba? 6 years and 1 day. Na may 1 day si prison mayor. So that is higher than prison correccional already. The law says no subsidiary imprisonment shall be imposed upon the culprit. Next paragraph. If the penalty imposed is not to be executed by confinement in a penal institution, but such fixed penalty is of fixed duration, the convict during the period of time established in the preceding rule shall continue to suffer the same deprivation as those of which the principal penalty consists. So what does this mean? Kung distyero ang penalty gi-impose sa imuha, follow the same rule nga applicable as the subsidiary imprisonment shall be the same as that of the principal. Meaning to say, i-extend imong distyero. It doesn't mean nga distyero imong principal penalty o nya dili ka bayad ni fine, prisuhon ka kay di ka bayad ni fine. So the deprivation those provided as the principal penalty shall continue. The subsidiary personal liability which the convict may have suffered by reason of his insolvency shall not relieve him from the fine in case his financial circumstances could improve. So meaning to say, since you cannot pay for the fine and the judgment of the court provides for a subsidiary imprisonment in case of insolvency, so naka-serve kag subsidiary imprisonment because of your failure to pay the fine. But the last paragraph says that if your financial circumstances should improve, despite the fact na naka-serve na kag subsidiary imprisonment, you will still be required to pay for the fine. So what is subsidiary imprisonment? It is a subsidiary personal liability to be suffered by the convict who has no property with which to meet the fine at the rate of 1 day for each amount equivalent to the highest minimum wage rate prevailing in the Philippines at the time of the rendition of judgment of conviction by the trial court, subject to the rules as provided in Article 39. The judgment of conviction must impose subsidiary imprisonment, meaning to say, the judgment of the court imposing upon the accused fine must provide as well, must state as well expressly in his decision that the accused or the convict shall suffer subsidiary imprisonment if he cannot pay for the fine. What is the consequence if the court did not state specifically in his decision that he shall suffer subsidiary imprisonment in case of insolvency? The same shall not apply, meaning to say, no subsidiary imprisonment to speak of, even if the accused cannot pay for the fine because of insolvency. Applicable only to fine and not to other pecuniary liability, okay? Only to fine. Can the convict be exempted from paying fine and just choose to serve subsidiary penalty? Okay, so Article 39 as amended apply only when the convict has no property with which to meet the fine mentioned in paragraph 3 of Article 38. Hence, it would seem that the convict who has property enough to meet the fine and not exempt from execution cannot choose to serve the subsidiary penalty instead of paying for the fine. Remember in the last rule that even if he suffered subsidiary imprisonment, he will be required to pay the fine if his financial status improves. So much more if he has there enough property to pay for the fine. Okay, let's evaluate this particular set of facts. A was convicted for bribery and sentenced to 2 months and 1 day of Arresto Mayor as minimum, to 1 year, 8 months, and 21 days of Prision correccional as maximum, and to pay a fine of 40 with the accessories of the law and to pay the cost. Since the decision does not provide for subsidiary imprisonment in the event of inability of A to pay the fine of 40, A cannot be required to serve subsidiary imprisonment if he appears to be insolvent. So if you notice, wala gi-provide. So that's why for his failure or inability to pay, he cannot be required to suffer subsidiary or to serve subsidiary imprisonment. So let's have an application to how you will apply subsidiary imprisonment. Under Rule 1, when the penalty imposed is imprisonment not exceeding 6 years. A is convicted of falsification by private individual under Article 172 and sentenced to 4 years, 9 months, and 10 days of prison correctional as maximum term of the indeterminate penalty and to pay a fine of 200,000 pesos. If A has no property with which to meet the fine, he will have to suffer subsidiary imprisonment, the amount equivalent to the minimum wage of 500 per day, which he cannot pay, but not to exceed 365 days computed as follows. So the 500 day is just for purposes of illustration. I adapted this or used this as the highest minimum wage prevailing in the Philippines. So how shall we compute it? Penalty, 4 years, 9 months, and 10 days. So 4 years, 9 months, and 10 days. So if 1 year has 365 days times 4 to represent the 4 years, so that would mean 1,460 days. That is in 4 years. And then we have to add 270 days for the 9 months, and then you have there the 10 days for a total of 1,740 days. Okay, so that is the equivalent of 4 years, 9 months, and 10 days. Now, take note under the first rule, it shall not exceed 1/3. Okay, 1/3. That's why we will divide this by 3. So 1,740 days, 740 divided by 3, that would give us 580. So that means that 1/3 of the penalty imposed shall be 580. Okay, so that is the 1/3 of the principal penalty. Now let's compute the fine. You have there the fine of 200,000 divided by 500, which is the highest prevailing minimum wage. The result would be 400. That would mean 400 days, which are less than 1/3 of the penalty imposed, which is 580. Remember, the losses does not exceed 1/3. So per computation, the subsidiary penalty shall be 400 days. Is 400, does 400 exceed 580? It did not. So meaning to say, we can, presumably, he shall be required to suffer subsidiary imprisonment of 400 days. But take note of paragraph 1, there is a further qualification here. Although the quotient of 400 days does not exceed 1/3, which is 580 of the prescribed penalty, yet A can be made to suffer subsidiary imprisonment only for 365 days. Why? Because the law provides, in no case shall it continue for more than 1 year. In other words, for the 400 days equivalent to the subsidiary imprisonment of the accused, he shall suffer only 365 days because the law says, while the same does not exceed 1/3, the law says it should also not exceed or shall not continue for more than 1 year. So the subsidiary imprisonment not to exceed 1 year, 1/3 of the penalty imposed, and not to exceed 1 year. So what would happen? Now, this 365 days or 1 year shall be added to his principal penalty of 4 years, 9 months, and 1 day. Okay, plus the 1 year or 365 days as subsidiary imprisonment. So that would be in addition to the prescribed or the imposed penalty upon the accused. To continue, what if the subsidiary imprisonment is only 40 days? Because the fine to which the accused is made to pay is only 20,000. So 20,000 divided by 500 equivalent to 40 days. When the quotient after dividing the amount of 500 is 1 year or less, and such quotient does not exceed 1/3, the penalty to be imposed, the whole period of imprisonment represented by the quotient must be served by the convict as subsidiary penalty. Now, let us say that of the penalty imposed upon the accused, same kana si 4 years, 9 months, and 10 days, but instead of 200,000, only 20,000, and he cannot pay. So following the same procedure, it will result to 40. Since 40 is less than 1/3 of the prescribed penalty and is less than 365 days, so the 40 is the additional days to which the accused shall suffer inside the penal institution as his subsidiary penalty. Now, what if the subsidiary imprisonment, if the fine is less than 500, less than the prevailing minimum wage, then no subsidiary imprisonment. Take note that a fraction thereof shall not be, no fraction or part of the day shall be counted. So, kung less than 500, unsa man na 2 hours. So, the rule says no fraction shall be counted. Okay, so I hope you are just following. Okay, let's proceed. Rule 2. Rule 2 applicable when the penalty imposed is fine only. Okay, fine only. So A was sentenced to pay a fine of 20,000. So this fine of 20,000 is the prescribed penalty for theft under paragraph 7 of the code. So in case of insolvency, A shall suffer subsidiary imprisonment at the rate of 1 day for every 500 still is my factor which he cannot pay. So to divide 20,000 by 500, that would be 40 days, equivalent to 1 month or 1 month and 10 days. So what would be his subsidiary penalty? Now take note that in Rule 2, it says there, not to exceed 6 months if prosecuted for grave or less grave felony, and not to exceed 15 days if for light felony. What is 20,000? It is light because it is less than 40,000. So, what would be the subsidiary penalty of the accused? Not to exceed 15 days, because the law says for light felony, not to exceed 15, even if per computation, the subsidiary penalty should have been 40 days. So since the rule says not to exceed 15 days, then this one prevails. Now, what if the penalty imposed upon the accused is 10,000? 10,000. So 10,000 divided by 500, how much? 20. Follow the rule. The rule not to exceed 15 days prevails. So still, the subsidiary penalty is 15 days. How about if it is 5,000? So 5,000 divided by 500, that would make it 10. Meaning to say, still a light felony. Will we follow this one? No. We have to follow the exact computation because it is less than the 15-day period. So his subsidiary penalty shall only be 10 days. That is 5,000 divided by 500, 10 days. Next rule, Rule 3. A was charged and convicted for falsification by a public officer punished under Article 171 and was sentenced to suffer the penalty of Prision mayor and a fine of 1 million. In case of insolvency, what would be A's subsidiary penalty? Okay, what would be his subsidiary penalty? No subsidiary penalty. Do you agree? Because the penalty imposed upon him is Prision mayor. Since Prision mayor is more than or exceeding or above Prision correccional, under this set of facts, no subsidiary penalty. Remember the rules? Okay, I just have to point out so that it would be clear to you. When the principal penalty imposed is higher than Prision correccional, no subsidiary imprisonment. So under those set of facts that he was sentenced to suffer a penalty of Prision mayor, then no subsidiary imprisonment penalty. The penalty to be imposed must be Prision correccional, arresto mayor, arresto minor, suspension, destierro, or fine only for subsidiary penalty to be imposed. Remember that subsidiary penalty is the same deprivation as those to which the principal penalty consists of. So, kani, deprivation of liberty mani, so it shall continue as far as the imposition of the subsidiary penalty is concerned. No subsidiary penalty in the following cases. So this is just a repetition. When the penalty imposed is higher than Prision correccional, for failure to pay the reparation or indemnification of the consequential damages and cost of the proceeding, no subsidiary penalty because subsidiary penalty is applicable only for failure to pay the fine. When the penalty imposed is fine and the penalty not to be executed by confinement in a penal institution and which has no fixed duration. So, subsidiary penalty also does not apply. Okay, penalty and accessory penalty inherent to it. Death, Article 40. The death penalty which is not executed. Okay, death penalty not executed by reason of commutation or pardon by the chief executive shall carry with it that of perpetual absolute disqualification and that of civil interdiction during the 30 years following the date following the death sentence, unless such accessory penalty have been expressly remitted in the pardon. What would be the effect? So, effect of the commutation or pardon, automatically, death penalty shall not be executed. The penalty to be imposed upon the accused shall be reclusion perpetua. Okay, and then this would be the accessory penalty. Perpetual absolute disqualification and civil interdiction. You have there the proviso unless such accessory penalty have been expressly remitted in the pardon. Now, by the way, what do we mean by accessory penalty? They are accessory penalty are deemed imposed. In the judgment of the court, he will provide for the penalty to be imposed upon the accused. In the examples that we have, finding the accused guilty beyond reasonable doubt, he shall suffer the penalty of 12 years and 1 day to 20 years of reclusion temporal and to pay a fine of blah, blah, blah. It did not mention of perpetual absolute disqualification. It did not mention of civil interdiction. Now, in the examples that we have earlier or here, okay, since the penalty upon the accused is commuted, this accessory penalty is deemed imposed. And when we say deemed imposed, it need not be specifically mentioned in the decision, impliedly included in the decision. That is what is meant by deemed imposed. Unlike for the subsidiary penalty, that the decision of the judge has to expressly provide for the subsidiary penalty to be suffered by the accused in case of inability to pay the fine. Okay, it must be expressly provided. But as far as accessory penalties are concerned, considering that they are inherent in each penalty, they are deemed imposed. Deemed imposed does not need to be stated expressly in the decision of the court. So that is Article 40. For reclusion perpetua and reclusion temporal, the accessory penalty that are deemed instituted or deemed included in the decision of the court are the following: civil interdiction for life or during the period of the sentence as the case may be, and perpetual absolute disqualification which the offender shall suffer even though pardoned as to the principal penalty, unless that accessory penalty is also expressly remitted in the pardon. How about prison mayor? The accessory penalty in prison mayor are the following: temporary absolute disqualification and perpetual special disqualification from the right of suffrage which the offender shall suffer although pardoned as to the principal penalty. The same thing unless the accessory penalty is expressly remitted in the pardon. How about prison correccional? The accessory penalty of prison correccional are suspension from public office, from the right to follow a profession or calling, and that of perpetual special disqualification from the right of suffrage if the duration of said imprisonment shall exceed 18 months. The offender shall suffer the disqualification provided in the article although pardoned as to the principal penalty, unless the same shall have been expressly remitted in the pardon. To just give you to visualize what do we meant by profession or calling, that the same is suspended. Now, if you are there being punished by the court, so you are found guilty of the crime charge against you, and while you are there inside the penal institution, you cannot practice your profession. So if you are there let's say a dentist, you cannot continue to practice your profession while inside the penal institution. Or if you are a lawyer, you cannot continue to practice your profession while you are there serving your sentence in the penal institution. Now, you might be asking, ngano lagi ng uban fiscal nga, mas kinaas prisuhan, no? Sige trabaho, blah, 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 blah. Now, take note, that could, those people that you might be thinking, for example, you have there Senator De Lima, di ba nagsige pa man siya og file, let's say a bill to the Congress, to the Senate. Now take note, he is not yet convicted. In other words, he is not yet serving sentence, so no accessory penalty is attached to her for the moment because he is not yet serving sentence. He is there inside under preventive imprisonment. Okay? So no sentence yet, not yet convicted. How about the arresto? Arresto mayor, arresto minor. So what is the accessory penalty of arresto? Suspension of the right to hold office and the right of suffrage during the term of the sentence. You also have there confiscation and forfeiture of the proceeds or instruments of the crime. So if the court will convict you or found you guilty of the crime charged against you, if there are any proceeds or instruments of the crime, the same shall be confiscated and forfeited in favor of the government. Every penalty imposed for the commission of a felony shall carry with it the forfeiture of the proceeds of the crime and the instruments or tools with which it was committed. Such proceeds and instruments or tools shall be confiscated and forfeited in favor of the government unless they be property of a third person not liable for the offense. Okay, unless owned by a third person not liable for the offense. Exception to the exception that even if the same is owned by a third person not liable for the offense, but that property is not subject of lawful commerce, the same will not be returned to the innocent third party. The same shall also be confiscated by the court for purposes of destruction, only when that article are not subject of lawful commerce. As a recap, every penalty imposed carries with it the forfeiture of the proceeds of the crime and the instruments or tools used in the commission of the crime. That's the general rule. The proceeds or instruments or tools of the crime are confiscated and forfeited in favor of the government. Parihara na sa mga shabu or mga paraphernalia whatsoever, so they are confiscated and forfeited in favor of the government. To be used by the government? No, but for destruction. Property of a third person not liable for the offense, not subject to confiscation and forfeiture, but if that property is not of lawful commerce, the same shall also be destroyed by the government. Okay, so that ends the first part of our lecture for penalty. I hope you learned something, and please just read the book of Reyes if you find the illustrations here insufficient, because what I did here is just a gist or a summary of what the author provides and had it presented in a way that is easier for you to understand. So thank you for your time and see you next time.